9:05 on a Tuesday morning, and time for feedback. It is Call the Lawyer today. Local attorney Corey Morgan in studio. Our guest, you got questions for Corey, 270-726-6100, or outside the local calling area, 1-888-610-WRUS. That's 610-9787. We'll be back with Call the Lawyer Day after these.
Boy, it sure is a busy time of year for folks around here. The kids are back in school and the harvest season is upon us. It's also the best time to purchase a new vehicle because incentives are the highest of the year. At Freeland Chrysler Dodge Jeep Ram, they sell cars every day, but you only buy one every few years, so they set out to make your purchase special. Freeland knows the community and is happy to do business with their friends and neighbors. At Freeland, they recognize that sometimes bad things happen to good people, so they offer a wide variety of financing options, and they're the area's only franchise dealer with a buy here, pay here program. At Freeland Chrysler Dodge Jeep Ram, they can help you get the vehicle you need while improving your credit, all with little to no money down. If you're looking to save thousands on a new Chrysler Dodge Jeep or Ram or one of their 50-plus clean used vehicles, visit them at Freeland Chrysler Dodge Jeep Ram, 1451 Bowling Green Road, Russellville. Call 725-4100 or visit them online at freelandcdjr.com.
This is Jerry White, and I want to talk to you about why you should make Raleigh White your healthcare center. First of all, experience counts, and I've been a pharmacist for 54 years.
This is Donnie Riley, and I have 36 years experience.
I'm David Guyon with 38 years of experience as a pharmacist.
And I'm Lindsay Flanders. I'm certainly not as old as you guys, but I've been a pharmacist at Raleigh White for nearly 7 years.
Think about it. We have a total of over 133 years of pharmacy experience, which means that we know about prescription drugs and their interactions with each other, and we're always glad to discuss your medications with you.
And what's more, Donnie, David, and I live right here in Russellville. The pharmacists in the big box stores don't live here. They can't know you and your families. You can always feel confident when you trust us, the experienced hometown people of Raleigh White on the square in downtown Russellville.
And again, it's Call the Lawyer Day on Feedback today. Local attorney Corey Morgan in studio with us. Good morning, Corey. Thank you so much for being with us this morning.
Thank you.
And so glad to have you. Folks on EPB Smart TV can see Corey in his dapper attire today. I like to wave at him just to know.
I can wave.
Yeah, just to know that they're out there. But again, local attorney Corey Morgan, our guest on Feedback today, and your chance for free legal advice. We do give the disclaimer and hope that you will certainly follow that. In your questions and comments, please do not be so specific as to say Joe Schmo is a low-down, dirty so-and-so and this and that. Please try to keep your questions broad in topic. Well, topic you can be fairly specific, but let's try not to be part of a lawsuit ourselves, Corey.
Absolutely.
See if we can avoid that. Well, I feel like the place that we must start, Corey, as it's been the top of ABC News at every hour thus far today, is the Supreme Court's, well, I guess the Supreme Court ruling to say that same-sex marriage is legal, but then the Supreme Court in not acting yesterday with Rowan County Clerk Kim Davis, and so there was a great debate over what she would do this morning as the office opened, and of course, as you probably heard by now, she did refuse to give licenses again today. So as an attorney, and of course as an attorney here in the Commonwealth of Kentucky, views not necessarily on the issue or the opinion of same-sex marriage and that, but the legal standing and the legal wrangling that we're going to see take place probably over the next several years, if I had to guess about it.
Right, absolutely. I guess first of all, I'm glad you brought that up because I was going to actually talk about that because that is big news, and I was wondering, I saw last night where the Supreme Court did say we are not going to, they essentially, they didn't make a ruling one way or another.
Right.
Of course, not ruling is a ruling.
Sure.
It turns out being just like a failure to decide winds up being a decision. It's just like that, it works that way legally as well. And I saw on WBKO, it says, update, county clerk continues to deny marriage licenses to gay couples.
Right.
And I'd kind of like to hear from the listening audience out there, what do they think about this? Now, I will say this: no gay bashing. We want only civilized discourse here. But
right.
But I would like to hear what people think about this. You have somebody who's either doing something really, really courageous or really, really stupid. I don't know which way that people are looking at it. But as far as legally speaking, whenever you deal with issues like this, you're dealing with the First Amendment. The First Amendment allows free exercise of religion. Now, what does free exercise of religion mean? I would like to take one of my citizens law school classes and just talk about. I mean, we could talk the entire hour about that, because there are a lot of Supreme Court decisions, lower court decisions, etc., that have told us what, in fact, that means. What does free exercise of religion mean? Do we have a call?
We do.
Okay, cool.
Good morning. You're on the air with Corey Morgan.
Good morning, Corey.
Good morning.
Like you said, I'm not going to say anything left or right of what's going on, but I do admire the lady for believing in what she believes in and standing for it.
Right.
I think that she's going at it right. I believe she's doing this because it's her belief, and I believe it's her religious belief that she's got, and I admire the lady for doing it.
Now, I guess if she's denying licenses to everybody, even heterosexual couples and homosexual couples, I mean, does that change matters any? Or is it?
Well, and my understanding is that's still the case.
Right.
That she's denying.
Well, it would show priority to one over the other if you split it.
Right. I understand where you're coming from.
It'd be them, not going by the law for both sides.
Yes, sir.
I mean, if she believes in not doing it, I can't see how she couldn't discriminate between the one coming in and letting them doing it.
Right. And
that's the way I look at it.
I agree completely. Now, one thing to mention, I was reading, I'll just read from time to time. If I've got time in court, I'll read the news or whatever. So I'll see things. And I did see that this job and any sort of public job, you can see what the salaries are of the person. She makes $80,000 a year by virtue of being a clerk.
Right.
And she's got quite a bit to lose. That's not peanuts.
Exactly.
She is really sticking her neck out there, and from the looks of it, she could wind up losing her job or in jail or both.
Exactly.
Is what it could be. But
it just shows how strong she is in her belief.
Right, and it does seem to be genuine. That's one of the things you always look to. Is it a genuine belief or not? But I see what you're saying. Thank you.
Thank you very much for the call. If you've got questions or comments, 726-6100 or 1-888-610-WRUS. That's 610-9787. I do think that it's an interesting legal case, taking and I know you can't take religious belief out of it, because obviously that's what the county court clerk is standing on. But the legal approach, in that she at this point is being supported by a legal team and legal advisors who are telling her, look, you're the linchpin, and so, we need you to do this, and we need you to fight this fight for, at this point, everybody else. Meanwhile, you've got the ACLU and you've got the folks on the other side of the issue. I wonder to a certain extent how... I guess my question is, at the end of the day, I wonder if this county court clerk, and I don't know her, I've never met her, don't know that I would recognize her if she walked through the door, but to a certain extent, I wonder if she's somewhat a pawn in this game, with two larger sides prepared to do legal battle, and she's going to be the one in the middle of it, and she may suffer the consequences, if there are any, when those who are at this point buffering her and supporting her, if that side ultimately loses legally, they go on to fight another day in some other state or in some other court of law. Meanwhile, as you mentioned, she's got she's an elected official with an $80,000 a year salary, and she's got that and potentially some freedom to lose. She's got a lot more skin in the game.
Oh, absolutely. She is the only one really with anything to lose.
Right.
You know, and that's what happens a lot of times in politics. You have one person, and they may have one particular legal issue, and then you have everybody comes out and supports or opposes, and they're fighting, and that person may wind up just like her, losing her job. And you know, and that's kind of, if I were a betting man, I would venture to say that probably will be the result, that she will have to be removed from office. I had even read where potentially they're thinking about criminal charges against her. You know, for not
dereliction of duty. Is that
correct? It's okay. I can't remember the name of it, what it was, but it was essentially not performing the duties of that particular office. And, you know, and I read both sides of things a lot of times, and the you know, the opposing view is people say, hey, you know, you've got a job here that is paying you money. You're being paid to do X, Y, and Z. If you're only going to do Y and Z and you're not going to do X, then you need to let somebody else in there who's going to do that sort of work. I mean, it's there are plenty of other jobs that would not violate her religious freedom, and you know, should she resign? Should she go ahead and resign if she has? You know, nobody should have to do anything that they don't want, that they have a problem with.
Let's take a call, Corey.
Okay, great.
Good morning. You're on the air with Corey Morgan.
Yes, I agree with what everyone has said, you know, all the legal terms and stuff like that. But what this lady is doing reminds me of two things. One is that song, you don't stand for something, you'll fall for anything. And two, the last time I looked at my Bible, God created Adam and Eve, not Adam and Steve. So, you know, I applaud the lady for what she's doing. Even though some people may think it's wrong, she could face legal consequences and stuff like that. But I still applaud for what she's doing.
Yes, I mean, I can see that. It's very, like I said at the beginning, see, they're very courageous or very stupid. I don't know which. I know that she has had, you know, a lot of criticism. It was even talking about in this story of death threats. And, you know, when you start, you know, it says Joe Davis says his wife has received death threats, and the couple changed their phone number. But he said he's not afraid, and he believes in the Second Amendment. I don't know what the Second Amendment has to do with it.
Well, he goes on, the later quote was that, because I saw the same quote in the Associated Press, that he was a redneck hillbilly, and you didn't want to come knocking on his door.
Right.
So that was the reference to the Second Amendment.
And you're right. The next sentence, he said, I'm an old redneck hillbilly, and that's all I've got to say. Don't come knocking on my door.
Right.
And I respect that. But yeah, yes, sir, I understand where you're coming from. Do you think maybe she should...
He's gone. I've actually got another one.
Oh, okay. I saw it blink, and I didn't know who it was. Go ahead. I'm sorry.
Good morning. You're on the air with Corey Morgan.
Good morning. Let me ask a question.
Sure.
Sure, we all would want to admire her for standing up for what she believes. But is she not being a little hypocritical? I mean, deciding not to issue any license at all. Now, before, she had no problem, and which is correct, issuing a license to a man and a woman. But now she says, I don't believe in issuing license to same sex, so I'm going to mistreat everybody. So she can't, I don't believe that she has the right to decide and mistreat everybody just because of one belief. Okay, if you're that firm in your belief, stick to that one issue that you have are not against, but still do your job and treat everybody else correctly. Otherwise, it's like when one of our children get punished, we're going to punish all of them because of that one, and that's not right.
Right. That's a very good point. Yes, sir. I agree.
Thank you very much for the call. Good morning. You're on the air with Attorney Corey Morgan.
Hey, Crazy Chris. How you doing this morning?
I'm good. How are you?
Well, I can't complain. I just wanted to put in my value in on this.
Okay.
You know, I think everybody's missing the whole story of this, and I don't know if Corey agree with me or not, but, you know, when you talk about which one's good, which one's bad. Ain't none of them bad. Us as Christians, we don't hate them people. It's the sin that they do is what the deal is, and they try to make it all out a whole different thing that they ain't even married. Number one, the fact of the matter, I'm standing behind the woman because if she loses her job, she may be making $80,000, but I guarantee you God will give her one bigger than the one she got, and everybody will have to answer for what they do once they get there. It's the Bible says it's an abomination for them to do that. Me, that's bad. But anyway, I just want to put my 2 cents in on that, and I appreciate it, Crazy Chris, and y'all have a great day.
I appreciate that. Thank you.
726-6100, 1-888-610-WRUS. If you've got questions or comments about this or anything with Attorney Corey Morgan in the studio with us this morning, it is Call the Lawyer Day. And, of course, discussing this because it's the topic that really has gripped the nation as far as national news this morning. Good morning. You're on the air with Corey.
Good morning.
Good morning.
I just had a little something.
Sure.
This, of course, this has been going on, but the Supreme Court, I don't know if you guys remember the trial they had over in Tennessee about the ball players and the sexual attack on
the Vanderbilt rape trial.
Yes. And you know they was declared a mistrial because one of the people that sat on the jury, if I remember right, he had been sexually assaulted. And so they dismissed it and called it mistrial. Okay, when the Supreme Court made this decision 5-4, and there was 2 ladies that voted for it that had performed same-sex marriage. Well, why would that be any different than the one over there? That should have been a mistrial too.
You're saying that you don't believe they would be competent to actually preside over a hearing like that when they have predetermined views. Is that what you're saying?
Well, according to that trial over there.
Right.
That's what I was going by. According to that trial over there.
Right.
That would be the deal.
And the Constitution does require a neutral and detached magistrate, somebody that will hear both sides equally without being swayed to one side or another, not prejudging the trial in any way. And it's the same way with appeals. I can see what your point. It's well stated. And you run into those problems, and then they'll say, well, I'm not prejudging the case just because I did this or that, and I'm not prejudging it. And I can see your point. That's a good point.
And as far as this lady that's standing up for what she believes in, now the Lord will take care of her.
Right.
Wherever she is, He'll take care of her if she's standing up for what she believes and what is a Christian thing.
Right.
I think He'll take care of her.
Right. And I wonder, does it make any difference to anybody out there that the fact that people can go to a neighboring county and get a marriage license? I mean, you don't have to go. People, I think, particularly same-sex couples who want to get married, they will specifically go to that county,
right?
Just to make a point.
Sure.
And which I understand that. I if I were in that situation, I probably would too. But just having a neighboring county, does that change anything?
Right.
But it's just beyond me. I mean,
right.
We know that's what happened to Sodom and Gomorrah when God brought judgment on them. So I mean, the person that's standing up for their Christian rights, I don't think they'll hurt. She may lose her job. She may lose her $80,000, but she'll gain a whole lot in return.
Right.
Okay. Well, thank you very much for the call this morning.
Thank you.
We appreciate you tuning in. Good morning. You're on the air with local attorney Corey Morgan.
Yes, it's an interesting conversation this morning.
Thank you.
What we have here, and what we seem to have forgotten, is this is a violation of the Supreme Court.
How so?
A judgment brought by the Supreme Court. Are we supposed to just throw the Supreme Court out? This kind of reminds me of George Wallace when he stood in the schoolhouse doors and said segregate. What if he'd have claimed that on his religion that it was illegal that it was immoral to segregate schools?
That's a very good point.
And also, too, got another point here.
Yes.
What about over in East Kentucky where they have snake handlers? Should she be allowed to have a snake in there? That's her religion, to handle snakes.
Mm-hmm.
We're opening up a can of worms. The Supreme Court has ruled, and I feel she needs to quit.
Mm-hmm.
Quote, she's stepping on my rights, too, as a non-believer.
Mm-hmm.
See, there's two sides. And the thing of it is, she is a pawn in the game with Richard Nelson on her side and the ACLU on the other side.
Mm-hmm.
They're not going to lose anything. It's only going to be her that's going to be persecuted.
Mm-hmm.
Now, you always heard this thing, you can't cure stupid. Well, this is the perfect case here.
Mm-hmm.
I think.
Yes. That's a very good point. I mean, I can see that. I can see that completely. And historically, the U.S. Supreme Court has ruled, if I were to summarize the legal rulings in just a sentence, I would say you can believe what you want, but your action can be restricted and regulated.
Religion enter into a lot of things it really shouldn't. Now, the lady was calling a while ago about these two ladies on the Supreme Court. What about Anton Scalia, who is a devout Catholic? He has an opinion on abortion already.
Right.
Before he ever took the office, he admitted, I'm a devout Catholic. I do not believe in birth control. I do not believe in abortion. And, of course, he doesn't believe in same-sex marriages. Now, he is opinionated on the other side.
Mm-hmm. Correct.
We can't sometimes let our personal beliefs interfere with the better good. Now, I don't know if this is better good or not, but the Supreme Court has ruled that it is, so live with it. Thank you very much.
Thank you very much for the phone call. I appreciate that. Good morning. You're on the air with local attorney Corey Morgan.
Yes, this is Shirley Markwell. I just want to say amen for that lady for standing up for what she believes in, and I feel like we all should take a stand for what we believe in. Thank you.
Well, thank you very much for the call, Shirley. We appreciate it. Good morning. You're on the air with local attorney Corey Morgan. Turn your radio down, please. That's why the program's called Feedback.
Yeah.
Can you get to there we go. You're on the air with Corey Morgan.
Much better.
I wanted to ask a question. I've got a mentally challenged daughter. She's got kind of mixed up with a man that's very influential, tells her he don't have to listen to me and all that stuff, and she goes and she don't respect my sayings or my rules or nothing, and I really am wondering what kind of rights do I have.
How old is the daughter?
Well, that might have something to do with it. She's 53.
Right.
But still, it's kind of a bad situation. She lives with me, and I thought, you know, that and when you had rules and anybody lived with you, you could have to kind of abide by them.
Yes, ma'am. I understand. How mentally challenged are you talking? Or are you a guardian of her?
I am her mother, and as far as the guardian, I don't have the guardian papers.
Okay.
But she, you know, has been with me and her daddy, which her daddy's deceased, but she has been with her with us all of her life.
Is she able to take care of herself? Like, is she able to feed herself, clothe herself, do all that sort of stuff? Is she?
You know, she don't really have that kind of a disability.
Okay.
She just don't understand things.
Okay.
I don't think she could live on her own. I don't think she could handle household affairs or nothing like that.
If can you give her money and she go to Walmart and buy something? Would she be able to do that?
Yes, to some extent, but I have to tell her, you know, how much it is, and and read it. If there's anything involved reading, I have to tell her and stuff like that.
Okay. Yes, ma'am. The reason why I'm asking, you know, you said mentally challenged. It can be, you know, profoundly disabled to mildly disabled. And does she receive a Social Security check for disability?
Yes.
Okay. So they've declared that she is disabled based upon, mentally.
Yeah.
Now, what you could do, if you believe she is making decisions that puts her safety in jeopardy, I mean, you could request to be her guardian if you believe that she's unable to take care of herself, either her personal affairs or her medical affairs or financial. If you think that she's unable to do any of those, you can, in fact, apply to the court for guardianship. Now that's done through the county attorney's office of wherever she resides.
Okay.
So, I mean, you can do that and ask for the guardian. What they'll do at that point is they will send out paperwork. It's called an interdisciplinary team. They'll have a medical doctor, a social worker, and a mental health professional. And those three will evaluate her and determine whether or not she can take care of her personal affairs, her medical, and her financial affairs. And they will make reports back to the court, and there will be a 6-person jury that will make a determination of whether she needs a guardianship. And like I said, there's one thing if you just don't like what she's doing. It's another if she's doing things that may cause her self-harm. If it's in the second...
she is. They're not very nice.
I understand.
I think he's kind of abused her, and I'm not talking hit or anything like that. I guess maybe you have an idea what I'm talking about. I hope so, but that's
right.
what it is. I think the sexual problem involved.
I understand, and if you believe it's going to...
and it's just hard, and I kind of would love to, kind of get rid of it. And there's not anything anybody could do to him, is it? They couldn't get him for interfering or doing anything like that?
Ma'am, she is, without a guardianship, there's really nothing that can be done. I mean, she is, I do realize that she's mentally challenged, but there are people in our society that have all kinds of disabilities, and they're able to function just fine. But once it gets to the point to where those persons cannot function, then a guardianship would be essential to ensure that they're taking care of it. And it very well may be. You might want to talk with the county attorney's office, just kind of give them the information and some of the background of things that she has done, maybe that you have concerns about, and they'll tell you whether or not they believe a guardian would be appropriate.
Oh, okay.
Okay?
Okay. Thank you very much.
Thank you, ma'am.
Thank you very much for the call. If you've got questions or comments for local attorney Corey Morgan, 726-6100 or outside the local calling area, 1-888-610-WRUS. That's 1-888-610-9787. We'll be back with Call the Lawyer Day after these.
Labor Day is almost here, and what better way to spend that extra day relaxing than picking out on your favorite picks from your Russellville Piggly Wiggly. Family pack fresh ground beef is $2.49 a pound, and whole Boston Bud pork roast is 99 cents a pound. Get 3 years of fresh bicolor sweet corn for $1, or stock up on great 99-cent specials like Dole Classic Coleslaw or Iceberg Salad Mix. Hunt's Ketchup, Kraft Barbecue Sauce, even 6-pack bottles of Kool-Aid Burst are all 99 cents each. You'll also find fresh watermelons at $3.99 and Van Camp's Pork and Beans, 5 cans for $3. 24 packs of Niagara Purified Bottled Waters are 2 for $5. Starkist Chunk Light Tuna in oil or water are 79 cents a can. And buy any 4 of your favorite General Mills cereals like Trix, Lucky Charms, Cocoa Puffs, and Cheerios and pay just $1.79 a box. Head in before Labor Day and stock up on all your favorite picks and your friendly and convenient Piggly Wiggly in the Bethel Shopping Center, Russellville.
I've often said air conditioning's my favorite modern invention, and to be perfectly honest, central heat doesn't fall far behind. It's amazing how much trouble it causes when a unit fails. But don't dare fret. Make one call to Knight Electric Heating and Cooling, and they can do it all. When the time comes to replace your unit, they'll provide you a free quote, offering options that will conserve energy and, more importantly, save you money on your energy bill. Plus, they'll throw in 3 free checkups. Buy before November 20th, and you'll also be registered to win a $500 Visa gift card. Knight Electric Heating and Cooling is a TVA-approved HVAC contractor serving the entire WRUS listening area. And once your new unit is installed, you can rest easily knowing they provide 24/7 service when necessary. Don't take chances with your comfort. Call Knight Electric Heating and Cooling at 270-726-3818. That's 270-726-3818. One call and they do it all. License number MO4318.
When you lose a loved one, a number of details must be worked out in a relatively short amount of time. The pressure of these decisions is only made worse by the grief the family is feeling. This is Wayne Reeves. Since 1959, our community has trusted Young Funeral Home to help them through this difficult time. As a family-owned funeral home, we understand the value of family and know that's how our friends and neighbors deserve to be treated. Young Funeral Home with chapels in Russellville and Auburn.
Call the Law Your Day with our guest local attorney Corey Morgan. Good morning. You are on the air with Corey Morgan.
Yes, I have a question, going to kind of shift gears here. When you have, of course, as you know, at least around here, when you get a divorce, you have a do-good order.
Mm-hmm. Correct.
And the judge signs it. How do you enforce that without having to pay thousands of dollars for a lawyer to get it done so? And I mean, how does a individual, when either individual can prove that that do-good order has been violated, how do you enforce that?
Mm-hmm. That's a good point. Go ahead.
I'm going to jump up off here so I can listen to you answer, because I'm on a cell phone and I'm not in a good area.
Okay. Well, thank you for your call. We'll get your question answered.
All right. Now, when you're talking about a do-good order, just for the listening audience, whenever there's a divorce, particularly a divorce that relates to children, that there's children involved, the court will sometimes enter an order. And I know historically over in Christian County they call it a do-good order.
Okay.
That's what the family court judge would do. And we started using it over. I'll sometimes submit one whenever I file a Logan County divorce. And what it does is the order will say certain things you can't do. You can't. It's for protection of the children typically, where you don't have things that are said in front of the children. You don't talk about certain things in front of the children. You don't get the children involved any more than necessary. And it also, a lot of times in the orders you'll have about not selling or disposing of any property, things of that nature. So, and the gentleman that called is talking about, well, how do you enforce an order? And it kind of gets to the point of I need to take one of our days and talk about enforcing orders and about how to prove things in court. Now, you have to enforce an order. There has to be actually a court hearing. The other side has to have an opportunity to dispute whatever it is you're saying that they violated. So typically that's done by motion. You'll hear the term motion a lot. All a motion is a request for a court order. And in that case, you're requesting a court order of contempt. And sometimes you'll see written motion for show cause. What that means is you're asking the other party to show cause why they should not be held in contempt for violation of a court order. And the burden is on whoever is alleging that the court order was violated.
Okay.
So, you have to say, hey, this court order was violated, and you have to present evidence in court. Now, when you present evidence in court, evidence has to be quality evidence. In other words, you can't present in court, that somebody heard from somebody that somebody violated the order. It has to be, you can't, that's called hearsay. It's an out-of-court statement used to prove the truth of the matter asserted. You can't use things like that. If somebody witnessed something, either they saw it or heard it, or, was involved in a situation in some way, those people are the ones who need to be in court. Other people who may have heard things or may not be directly involved, those persons are not ones to be in court. So if in fact there is a violation of a do-good order or any order, you want to make sure that you can prove that a violation occurred. Now, we all know, what you can prove is what matters. And unfortunately, a lot of cases, things are going on, certain things have happened, but you can't prove it.
Right.
So it would be a waste of your time and everybody's time if you file something without having the proof. So make sure you try to gather as much proof as possible. Now, the main question was, how do you do it without spending a bunch of money with a lawyer? And anything that a lawyer can do that deals with you personally, not representing you're a business or anything, but if it deals with you personally, you can do. You do not have to have a lawyer to do it. Now, sometimes that gets people into trouble.
Sure.
It gets people in trouble because you can do something that may be wrong, and you get fussed at by the judge and all that sort of stuff. I've seen cases before, not very many, but I've seen cases where the person has to pay the other person's lawyer fees because they do something all messed up. But I will say that the court here, I believe there's in Logan County, has a motion for visitation there, and it's like a sample motion that's blank. You can take one of those and just modify it. You'll need to, if you've got a computer, just modify it and have motion for contempt, and just say whatever it is the person's doing to violate that do-good order, and ask the clerk for a date. Actually be the judge's secretary in Logan County for a date, of when to have the hearing, and you file the original with the court and mail out a copy to whoever is involved with the case, whether it's a lawyer, whether it's other party, whoever's involved in the case needs to get a copy of it, and the court always gets the original of that. But in answer to your question, I really don't know of anything you can do aside from doing it yourself or paying a lawyer.
Right.
Now, you don't have to hire the first lawyer you talk to. It's like buying a car. You don't buy the first car, at least I hope you don't. I'm sure there's some people out there that do, but I hope you don't buy the first car that you talk to a salesman about. I hope you look around and that sort of thing. Now, sometimes people hire lawyers because they know that lawyer's reputation. They know the lawyer does a good job. Maybe a bulldog or whatever, whatever reason is that they think that they need to hire that attorney. But, there's a lot of, particularly motions that are routine type motions, any attorney can do it, without any problem at all. But in answering the question about that, I think that I would do it myself unless I could call around and find somebody who could do it for, somewhat reasonable.
Right.
Because I hear sometimes what other attorneys charge, and most of them are reasonable, but I'll occasionally get one be like, oh, I went to so and so, and they charged, $2,500 for this, this really small motion.
Right.
And I'm like, man, that's kind of high for that sort of thing. So I mean, you can call around and try to find out what it is that you want to do. So anyway, I'm just going to jump topic to topic until we have some
right
more
ahead.
people.
Let me give the numbers one more time. If you've got questions or comments, 726-6100 locally, 6100, or outside our local calling area, 1-888-610-WRUS. That's 610-9787 if you've got questions or comments for Attorney Corey Morgan.
Okay.
Carry forward.
Now, what are the requirements of a will in Kentucky? I'm going to hit wills a little bit. In Kentucky, you can have a will, but you have to be age 18 years of age or older, of sound mind, and the will has to have 2 witnesses, and the witnesses have to sign in the presence of the person who is making the will. They call it the testator. It's in the presence of the testator and in the presence of each other. Now, even though persons under the age of 18 cannot have a will to dispose of their property, a person who is under the age of 18 can make a will. Like there's a statute that says minor may make will. No person under 18 years of age may make any will except in the pursuance of a power specially given to that effect, and except also that a parent, though under 18 years of age, may by will appoint a guardian for his child. So wills, typically people think, oh, give my property. Sometimes wills, you appoint somebody or ask the court to appoint somebody who is going to be guardian of your child or children.
Right.
And that's very important because children will be appointed, whoever you say is guardian, unless there's reason not to. Maybe the person is unfit or something. But that's important. Now, keep in mind, people have a superior right to custody for their children, so you can't be a mom and say, I want to appoint, my aunt, guardian of the person and property of my child, when you have father over here. The child's automatically going to go to the father. But if father and mother could say we want the same person, or it could be maybe there's not a father there who's involved, or maybe not a mother involved. So in those situations, it is important, and in just any situation that you have a will and have children, you do want to put in there who's going to be the guardian of those children.
Good morning. You're on the air with Corey Morgan.
Yes, it's me again. Let me turn my radio down. Okay, Corey, you just touched on a subject that I'm curious about. I've got a mother-in-law who is paralyzed, and it is a job to move her around.
Yes.
Is there any way possible, because she wants to make a will, is there any way possible someone could come to our house and do the same thing?
Yes. The biggest question, I was actually involved in a lawsuit a few years ago, and the lawsuit was because I had gone to the hospital, nursing home, and had the testator sign the will there. And there's a big question of, well, was the person of sound mind or not? And it turns out, yes, several doctors said yes, the person was of sound mind, and the lawsuit essentially went in favor of the will. But what I'm getting at is that's some of the issues you run into sometimes. So it's best, I think, if you have outside of a lawyer's office. You go in a lawyer's office to do a will, the lawyer's going to be there. There'll be a legal assistant, a lot of times a secretary. You'll have people there, and they can view the person. They make sure the person is of sound mind. Talk to them. See if they know what's going on. One of the things is they call it natural objects of your bounty. You got to know how many children you have. If you go in there and you got 3 kids and you say you got 1 child, that's a problem. So you got to be able to know, and so it's important for a doctor, I think, in a situation like that, to say, how the person is mentally before they sign something. But yes, you can be perfectly fine to have somebody come over and watch her sign the will. You just got to have 2 witnesses in order to do that. So the answer to your question is yes.
Yeah, well, see, the only problem with my mother-in-law is she had a stroke, she's paralyzed on her left side.
Right.
And I'm thinking she's like 80 years old, and she's wanting to get a will signed. But that's the reason why I just want to call and touch base with you on it.
Right, yes. She can sign a will. Just somebody's going to have to, particularly a doctor in that situation, to see that she knows what's going on around her, and somebody needs to read the will to her and to where there's not any sort of undue influence or anything like that. That's an issue that can come up as well. It's always best to do a will when somebody is healthy, when they're, able to go in a lawyer's office. Once they start to have problems, then
it's best to do a will when you don't think you need one.
Yeah, when you don't think you need one is the best time. That's exactly right.
Okay, now, my next question is, who can we get to come out here?
As far as an attorney, or as far as, you just have to have 2 witnesses, okay? 2 witnesses to witness her signing the will, and the witnesses can't be any sort of heirs of the person. Like it's best if they're not family members. I typically don't like to have family members because you don't know if they're going to be an heir at some point, and then you get an issue of that. As long as you have a couple of witnesses, a lawyer can draft up a will for you, and you can take the will there. And always have a notary too. Whenever I do the wills to sign it, because there's something called a self-proving will. The self-proving will means you don't have to have one of the witnesses swear to the validity of the will and the that the testator was of sound mind. So, yeah, and the best thing to do is just talk to a lawyer. You know, some lawyers might be willing to go out there and do that. You know, but whoever it is, this witness in the will needs to be a real witness and know that the person, you know, knows what's going on.
Okay, thank you very much.
Thank you.
I'll talk to my mother-in-law back.
All right. Thank you very much.
Thank you very much for the call. We're going to take our final commercial break. We'll be back with local attorney Corey Morgan after these.
This is Jerry White, and I want to talk to you about why you should make Raleigh White your healthcare center. First of all, experience counts, and I've been a pharmacist for 54 years.
This is Donnie Riley, and I have 36 years experience.
I'm David Guyan with 38 years of experience as a pharmacist.
And I'm Lindsay Flanders. I'm certainly not as old as you guys, but I've been a pharmacist at Raleigh White for nearly 7 years.
Think about it. We have a total of over 133 years of pharmacy experience, which means that we know about prescription drugs and their interactions with each other, and we're always glad to discuss your medications with you.
And what's more, Donnie, David, and I live right here in Russellville. The pharmacists in the big box stores don't live here. They can't know you and your families. You can always feel confident when you trust us, the experienced hometown people of Raleigh White on the square in downtown Russellville.
Choosing a funeral home requires enormous trust. This is Joey Young. At Young Funeral Home, we've been earning the trust of Logan Countyans since 1959. Because we are a family-owned funeral home, we understand the importance of treating you like family. We invite you to call us at your time of need or come in and discuss the benefits of pre-planning a funeral with our staff. We create personalized services that honor your loved one. Young Funeral Home with chapels in Russellville and Auburn.
Call the Lawyer Day today on Feedback with local attorney Corey Morgan. Good morning. You're on the air with Corey.
Hello.
Hello.
I have a question about concerning children.
Mm-hmm.
In Kentucky, what is the age that a child can choose which parent they want to live with? I have a friend that has a child that is autistic, and someone had told him that he's 14 and that he could choose at this age which parent he wanted to live with.
That's a good question. I get that question quite a bit, actually. In Kentucky, there is no specific age. And the reason why that's that you have to take into the account the wishes of the child. Now, if we will logically, if we can think for a moment, why is it that there's no particular age? Well, different children develop at different rates. Some children at age 12 may be, like my daughter who's like 20, at age 12, and some might be, age 12 and be on the level of maybe an 8 or 9 year old. You really don't know on that. But the court is supposed to look to the child. The fact the child is autistic would actually go against, because that's a health issue that would make it less likely that the child would know what his or her best interest is, because children a lot of times they'll choose not what their best interest is. They'll choose who the more lenient parent is. They'll choose a parent who will let them stay up all night and drink Cokes all day and that sort of thing, versus somebody who goes to bed at a reasonable hour and makes them drink milk and orange juice and water and stuff. If you have a choice, that child's going to choose the one that is not necessarily the better parent, but the one that gives them more freedom, more of the things they want. So that's why typically in Kentucky, well, not typically, but Kentucky doesn't have a specific age, and the judge is supposed to look to that as well. And I was looking at the custody statute, and y'all can always if you've got a computer, you can always go to Google and type in Kentucky Revised Statutes, and it'll pull up the statutes, and what I'm looking at is 403.270. So, and it talks about custodial issues. Once again, that's 403.270. that's the custody statute. And it says down here, the court shall determine custody in accordance with the best interest of the child. That's one of the primary focus is the best interest of the child. And equal consideration shall be given to each parent and to any de facto custodian. Now, what a de facto custodian is, it's somebody who's had the child for a long time, been primary financial supporter and caregiver of the child. That's usually not the issue. It's usually between parents. So you have equal consideration. Does that mean there aren't judges out there who prefer the mother? No, that's not the case at all. They're not supposed to, but there are definitely judges out there who kind of lean towards the mother, maybe for boys, lean towards the father, things like that. But you're supposed to be totally equally. And they look to these factors. It says the wishes of the child's parent or parents and any de facto custodian as to his custody. So the parent's wishes. B says the wishes of the child as to his custodian. It doesn't say any ages. It just says the wishes of the child as his custodian. That's one of the relevant factors that the court has to determine. C, the interaction and interrelationship of the child with his parents, his siblings, and any other person who may significantly affect the child's best interest. So that could be not only how you relate to siblings. So if you've got, say, a couple of siblings in one house, no siblings in another house, well, the house with siblings is kind of preferred because where you get a relationship with the siblings. If you've got a relationship already, could be if you have a good relationship with your cousin, living with your dad, living with your mom, you don't have that. They have to look at all those sort of things. The grandparents come into play as well. It says D, the child's adjustment to his home, school, and community. How well adjusted is the child? That's one of the big issues on that. E, the mental and physical health of all individuals involved. Now, this particular case, if you have a child that is autistic, the health of that child would make that child less likely to be able to determine, where he or she wants to stay. Then you get into domestic. I know we got a call, don't we?
Yeah, but she's still on the line as well. So
okay. Right. We got you look to domestic violence. You look to, let's see here. Yeah, that's pretty much it as far as what they look to. But those are the factors that the court has to determine on that. So the answer to your question, that's a very, very long-winded, answer. But the answer is no. There's no specific age. But yes, the court does consider the child's wishes, and the older the child, the more the court will consider those wishes.
So the non-custodial parent, if the child wishes to live with the other parent, could they just go and, like you were talking earlier, file a motion for a hearing, and so that the child could talk to the judge and let the judge know what that is? Correct. It's now, once again, it's discretionary with the court about whether or not to even talk to a child. The court does not have to talk to a child, but I think really an older kid, you've got the right to actually have that child, put the child on the stand and say, hey, what do you want? But the biggest thing is not what the child wants, but why. That's the biggest thing. If the child wants to be with the other parent for a good reason, a good wholesome reason, a reason that will help that child mature and be educated and that sort of thing, that is the best way to try to get the change. And vice versa, if you don't want the child going over, you say these are the problems. These are why the child has it better here. These are the problems over there. So that's how that works. Okay, thank you.
Thank you. Thank you very much. Corey, we've just got about 2 minutes left. I know that's not, in lawyerese, that's not a lot of time. Right. But briefly, going back to wills for a moment, because it's something that I know that's come up several times, and I believe that I remember your advice being pretty staunch. Why should married couples not have a joint will?
Okay, because it is a contract. That is a hard and fast rule. I have very few. 99% of everything I do is not hard and fast rules. It's like, let's look at the situation. There are a few hard and fast rules. Don't consent to searches. Do not do it. That's hard and fast rule. Don't ever do it for any reason, ever. Another one is don't do a joint will, ever, for any reason. Don't do a joint will. Why? Because it's a contract. Husband and wife, say husband dies, because women live longer than men, you know.
Yeah.
Yeah. Anyway, husband dies, and wife is stuck with whatever wife has in her will.
Right.
What if husband and wife do a joint will and husband dies at 30 and wife has 50 years to live?
Right.
So I mean it's just not a good idea. I don't see it very often though. It's not something that I'll normally see very often.
I think that was probably something that was more common in a different generation.
It was.
And so it's probably an older generation now, and I guess that's part of the reason that I wanted to throw that out there, is because I knew it was a hard and fast rule for you. And if somebody's out there with one, you might want to consider getting it changed.
Yeah, get it changed while both parties are still living. Right. Just get rid of it. Okay?
Corey, thank you so much for being with us. Really enjoyed it. Enjoyed the conversation. That's Corey Morgan, local attorney with Call the Lawyer Day. I know Don will be getting back with him and hopefully have him back for his regular monthly visit in October. Tomorrow, join me, 8:30, we'll have Shelter Talk with Tracy Moser from the Logan County Humane Society, and local Logan County PVA Ben Brown, my feedback guest tomorrow here on WRUS. It is now time for ABC News. I'm sure we'll get the latest out of Rowan County now on ABC News. You're tuned in to AM 610.